Now we're going to take a look at some federal programs that have been formed with the goal to end discrimination in general, and in this case, and specifically in the labor force. The first was the Equal Pay Act of 1963. Prior to this law, gender-based discrimination was sanctioned and was legal. Employers were allowed to prohibit women from working too many hours, working at nights, or lifting heavy objects, and working during pregnancy. So they couldn't prohibit that, or they were allowed to prohibit that. The Equal Pay Act made all of these acts illegal, and it also disallowed different pay scales based on gender alone. So you couldn't tell a male that after 5 years they would get a 10% raise, but for females after 5 years they would get a 5% raise. And so explicitly having this these type of practices became illegal. Now, this did help reduce the gender wage gap, but it didn't eliminate it, as we've talked about. Title VII of the Civil Rights Act. So the Civil Rights Act was a sweeping law. It addressed a lot of areas, but specifically Title VII of it. Out of Title VII, the Equal Employment Opportunity Commission, the EEOC, was formed, and they were the group that became responsible for enforcing the provisions of the law. And so anything that was covered on the Civil Rights Act, the EEOC became a group to oversee it. This was a way to prevent those discriminated against from having to go out and get lawyers or need to monitor it themselves. And so this was the way for the federal government to ensure that this was not going on. So also under Title VII, it became unlawful to, and I quote, to refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to compensation terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So this prevented a lot of, it made it unlawful to practice a lot of different types of discrimination. It has been amended, adjusted over the years, but this basic core has remained in place. The final type of federal program that was put in place is the Federal Contract Compliance Program in 1965. And this deals specifically with federal contractors. It set up affirmative action requirements for hiring and promotion for any firms that wanted to be, or any companies that wanted to become federal contractors. So again, there were a lot of additional smaller laws that have been impactful in addition to state laws. So there's a lot of state laws that vary by state. Some work toward, some are more focused on achieving this type of equality. Others are not as concerned. But these three are the main ones that have come into play over the years.